We will resume. We're broadcasting, excellent. I now welcome Professor Kim Rubenstein to the table. For the record, would you please state your full name and the capacity in which you appear before the committee?
Thank you, Chair. Yes, it's Kim Rubenstein, and I'm a Professor and Director of the Centre for International and Public Law at the Australian National University, and I'm appearing here in my own capacity as an academic specialist in the field.
Thanks, Professor. Although the committee does not require you to give evidence on oath, I remind witnesses that this hearing is a legal proceeding of Parliament and warrants the same respect as proceedings of the House itself. Giving of false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. The evidence given today will be recorded by Hansard. Do you wish to make some introductory remarks before we proceed to questions?
Thank you, Chair. I would like to do that. I'm grateful for the opportunity of presenting before you and am delighted to be able to engage fully in an area of both academic interest of mine, but also I think as an Australian citizen, and all Australian citizens will be fundamentally affected by this bill. I'm grateful for the opportunity to really provide an avenue for this committee to think very seriously about the place of this bill in our Australian democratic system. As my submission, as I hope you've all read, has outlined, I have broad concerns about the overall purpose of the bill, and I'm happy to take questions in relation to that in terms of the trajectory of citizenship in Australia and the way that it has evolved from being understood solely as subjects of the Commonwealth, and that move from being a subject of the Commonwealth to being both a subject and a citizen, and then finally, in terms of that evolution, to solely being Australian citizens. And in addition to that being a reflection of our change in our relationship with the Commonwealth and with the United Kingdom, I think it also profoundly represents a change in terms of the Australian multicultural society and a vibrant democratic nation in a globalised world, in that the status of citizen is something quite profoundly different to the status of subject. It is a status that reflects an equality both between members of the citizenry, but also between the relationship between the individual and the state. So my first main concern is the change that I believe that these revocation amendments make to the proper balance in relation to the executive and the individual in relation to membership of the community. The second concern that I have is in relation to what I believe is a worthwhile purpose of this government to be concerned about issues to do with terrorism. I have absolutely no concern or objection to a government doing what it should do to protect its citizenry, but I firmly believe that it shouldn't be in the context of citizenship. I see citizenship as being something much more profound, and that there are better ways and more appropriate ways for us as a nation to be dealing with the concerns about terrorism in a globalised world. And I think that even more particularly in relation to the fact that this bill ultimately is targeting dual citizens, and that in a multicultural nation the consequence of that will actually be counterproductive to the very principles of trying to create an inclusive society where members of the community are not attracted to terrorist activities or to activities that are against the Western liberal democratic system. So that I see the bill as having a possible counterproductive outcome for the very purpose that it is being introduced. So those are my two broad concerns about the purpose and objective of the bill. And then, as I've explained in my submissions, I have key concerns in relation to the mechanics of the bill and the constitutionality of the bill. And those aspects come back to the fact that citizenship in the Australian Constitution is a curious subject, in the sense that citizenship is not set out, Australian citizenship is not set out in the Australian Constitution, and so it leaves the parameters and the extent to which the Commonwealth can legislate in this area less clear than other areas in the Constitution. But from the aspects of constitutional law that have developed over the years in dealing with some of these issues, there are very real concerns about the constitutionality of these provisions. then, beyond those strict constitutional law questions, there are more profound rule of law questions that many of the submissions have been raising for the committee's concern in relation to knowledge of the law, knowledge of when you have lost a profound status such as citizenship, so being bound by a system where individuals are aware of the legal framework that they are working within and the status that they hold at any given time. And then in relation to rule of law concepts in terms of the automatic nature of these provisions and the consequences that has in relation to people's status and a clear sense of their position in society. So those, I'm happy to answer questions in relation to the specific provisions and concerns I have, as I've set out in the bill. And then the final point that I make is in relation to an issue that I've raised in the context of the overall purpose of the bill, of the notion of the vulnerability of dual citizenship. So that in a globalised world in which dual membership and connections to more than one nation state are becoming more and more common, we're seeing this bill representing a backward step in terms of the disadvantage of taking up dual citizenship. That the consequence of this bill is that dual citizens are placed in a vulnerable position in Australian society, and that it's something that actually has an impact on all members of the community. So it's not just the potential terrorists who are effectively more vulnerable, but all Australian citizens. And to make that point before I answer questions, I had the opportunity of making a submission to the citizenship consultations that the Honourable Philip Ruddock is a member of.
I'm sorry I was away.
You were away, but I had the opportunity of presenting before Senator Concetta Fierranti-Wells. And I made the point to her on reading her very impressive biography that she is a person who would be vulnerable under this particular act. And can I give you a reason to help you understand that? On her biography, which is a very impressive multicultural biography, she represents the Australian Italian community at an international level through the General Council of Italians Abroad. And she's been given awards. She's a Knight of the Order of Merit of the Italian Republic. Now, I would say that is wonderful in terms of the connections between Australia and Italy and the benefits that flow to Australians and to Italian Australians as a result of that. Over the years, she's participated in a number of other organisations, including fundraising activities associated with COASIT. Now, COASIT is an Italian Association of Assistance. Now, as I explained to her, it could be that when she was a member of COASIT, that body gave support to an Italian-Australian member of the community, a family in need of support, and that family may have had a member of that family who, on various of the provisions under the revocation powers in relation to criminal conviction, that funding might have assisted someone who had used that for terrorist activities. Now, theoretically, under the Act, when the Senator was a member of COASIT and fundraising for COASIT, that could lead to a conviction under the provisions under these revocation powers that would, as a matter of automatic consequence on conviction, lead to loss of citizenship. Now, that might seem an extreme example to you, but in reality, it is caught within the provisions as they currently are placed. And I think it's a good reminder, not only that those sorts of provisions, but the provisions in relation to destroying Commonwealth property that are included in the range of convictions are far too wide, but they are reflective of what I think is a profound problem with the Act in terms of its purposes not being properly reflected in the nature of the legislation.
Senator Fawcett.
Thank you, Chair. And I'm glad to report for Senator Fierranti-Wells that by virtue of the fact that she is a senator, she wouldn't be at risk because she can't have dual citizenship. But we'll move on to the substance.
I missed the earlier conversation about that point, actually, which is quite an interesting one.
We'll move on to some of the principles underpinning the intent of this bill. You've written in here quite a bit about the concept of allegiance.
Yes.
And in the context of a globalised world. It strikes me, and I'd like you to explain, if you could,
yes,
that you're almost challenging the concept of the Westphalian nation-state and the concepts of loyalty and belonging to your primary state that you
Yes.
call your nation.
Great.
Could you expand
Yes, I'd
a bit
love
on
to
that?
have the opportunity. So I brought the book along that I'm the editor of, Allegiance and Identity in a Globalised World, and I commend it to those who are doing work associated with this bill to have a look at. This book drew together academics from both around the country and internationally to look at these questions about allegiance in a globalised world. And it does not in any way say that it is going to be the end of the nation state, but rather that it is more and more common for people to have multiple connections to multiple nation states without that undermining any single one. And I think the best way of understanding this is to think of our approach to marriage as opposed to parenthood. I think this bill sees citizenship like marriage, that you can really only have one partner, one allegiance, whereas we have moved to a state or a situation where citizenship is like parenting. We can have more than one child, we can love more than one child without that undermining our love for any single child. We can have connections to more than one nation state without that undermining our connection. I think of allegiance as a real and meaningful connection to a nation state. And it's only when there is that direct conflict between the two, where one is leading to the end of the other. So when you have one child who's seeking to kill the other child, that there is a conflict in your parenthood. That is the only context where a notion of direct conflict arises. I believe we should think of allegiance like parenthood, and that this bill does not reflect that at all.
But excuse me wanting to challenge it.
Sure.
There may be some states that don't have the same values that we have. You may say a person can share them, but there are some states that are quite explicit that they do not acknowledge different religions. I guess the point I'm saying is you might have difficulty in having shared values that are common and across the board if the states have in fact quite different approaches. For me, citizenship has those certain elements of commitment to the rule of law, parliamentary democracy, the accepting people of different backgrounds, different faiths, different religions, but the fact that you accept those differences doesn't mean you forego the common elements that bind us all together.
So this is a really interesting discussion about the nature of allegiance or shared values, because allegiance is about your responsibility to the continuation of the nation state. We can look around Australia today and see many people who have very different values, but that doesn't undermine their sense of connection to Australia. They might express those values differently, and that's where the criminal law system comes in to say a society accepts or doesn't accept those values or behaviours. But I would argue that the criminal law is relevant to an expression of a rejection of those values,
But I might argue that the criminal law, if you actually look at some of the people who've been convicted of terrorist offences, is having no impact. People are going into our jails and being further radicalised, and those who have been convicted are radicalising people.
But then I think that the attention should be to that legislation rather than using another piece of legislation like the citizenship legislation.
I guess the argument I would put is that you're suggesting citizenship is so much more important that it ought not to be threatened.
Yes.
I'm saying it is so important that if there is a threat to that for those people who are engaged in terrorism, it may have a greater input on their behaviour than our criminal legal system.
Well, I guess there are two responses to that. One is that the attack on those values is not necessarily an attack on the citizenship, and I guess it's a different configuration of the meaning of citizenship as a form of membership. And membership doesn't mean that you all have to think the same thing. We live in a diverse society.
Well, I think it does in relation to what I believe are the commitment to the rule of law and parliamentary democracy and those elements that I talked about. I mean, there are some people who think that the commitment is only to difference. And while I think we should be tolerant of those differences...
But the commitment to the rule of law is a commitment to the system of the rule of law, which includes the system whereby citizenship is the foundation to that rule of law. So once you start attacking citizenship, you're also in effect, attacking the very system of the rule of law that you're seeking to protect. So you get yourself in a bind in that respect because you're actually undermining the core fundamental value of the rule of law.
I shouldn't have interrupted my colleague.
But it does strike to that different conception of the nature of the value of citizenship in a society. And I would respectfully submit that the criminal law system is a more appropriate system because it is affirming the nature of the role of law in society as the means to deal with different expressions of value. And then the consequential question is, if you do remove those people from the Australian community, you're still left with those sole Australian citizens who express those same values. And so to that extent, you are creating a very unequal system in relation to the ways in which the rule of law plays out to dual citizens versus single citizens. And then there are the further international law questions of how we are being responsible as an international citizen by sending out all those people who reject those principles. We're not saying you can't do them, we're just saying you can't do them on our shore, and we are actually members of an international community where we have committed to fighting against terrorism in an international world. Well, we're saying we're only fighting to the extent that it doesn't happen on our territory and therefore other countries can be responsible for those citizens. And that, of course, is another normative question as to Australia's role in an international system which has been committed to fighting against terrorism.
So if I can bring you back, even using your analogy, every parent will know that children have their own personalities and make
Yes.
their own decisions. So the argument that you were running there was that you can have allegiances to two places, in Senator Fianti-Wells' place, to Italy and to Australia.
Yes.
But the case we're looking at here is where people make a choice to say my allegiance, in the current context, is to the caliphate.
Yes.
And I'm going to leave Australia. I'm going to go and pledge my allegiance to the caliphate. So it's not to the other country where they might have citizenship.
Yes.
They've actually gone to a third place to engage in activities that are not consistent with their obligations as an Australian. In fact, in some cases, they're actively seeking to kill our citizens or servicemen and women who are over there. So in a case like that, would you still argue that that person should be accepted as part of the big happy family of Australians, as opposed to accepting the fact that they've actually exercised their own free will, they've made a decision that they don't want to be part of us? Why should we extend to them the privileges that come with Australian citizenship if they've voted with their feet in their actions to depart from what's accepted as normal, acceptable, humane behaviour?
So I think there are two elements to my response. One is that I do believe the criminal law should come down upon them. I don't agree with any of that action, and I think that we need to do something. But it is about prosecuting them and making them responsible for that activity, being part of the global international fight against that activity, and punishing them in the way that they can be put in jail and told that that is totally unacceptable as Australian citizens, as opposed to banishing them as a result of that. I think the second aspect to it, which is directly related to the bill, is in relation to the former Section 35. I understand the point that you're making, and I think that it's a fair point if you accept Section 35 as it currently exists, as being a section that has been there since 1948. I do appreciate that the nature of the globalised world has meant that connection to a nation state now, because of the nature of the world, is not just through nation states. And so that a membership of an organisation that is seeking to fight directly against Australia, I think that if you accept Section 35, you can modernise that section and that section only in terms of this bill's purpose. That would be, to me, the extent to which would be proper within the framework of our current citizenship, at the place of citizenship in Australian society. So that Section 35, as it currently stands, which, as I've noted, has never been constitutionally tested, so we're not sure if it would actually hold, but in the event that it did, modernising that, I think, would properly take into account your concerns.
Thanks, Chair.
Thanks, David.
I wanted to ask something by way of clarification, which Mr Byrne's asked me to ask, just before I go to some constitutional questions with Professor Rubenstein, and it's whether or not the solicitor...
Rubenstein.
Forever, everyone's going to be caught now.
Rubenstein.
You go with Professor, I think.
Double E-N.
That's what I did.
And that's whether the Solicitor General's advice is going to be made available to the committee. Mr Byrne asked me to ask. He's mentioned it with some other witnesses, but that's because you, Chair, have actually said that the Solicitor General has said that this bill is constitutional on public radio this morning. It affects the questioning I'm going to ask of Professor Rubenstein.
No, we won't be. I mean, there's a practice that won't be made available to the committee.
Well, why is that? Because you've actually revealed to the public of Australia the substance of the advice.
I have not revealed the substance of the advice at all. And I think let's have the discussion with the professor, and then if you want to have this discussion when we've finished, I'm happy to continue.
Well, we'll take it up again then, but you've made it clear on public radio this morning that you said the Solicitor General says that this bill is constitutional.
All right, let's have the discussion once the advice is...
Chair, can I just... The issue of constitutionality has been raised not just by Professor Rubenstein, but by, I think, the Law Council, Professor Williams, and other submitters. And, I mean, leaving aside your willingness to make public comments as the chair about the constitutionality, if that's... Surely that's a matter that it's difficult for us to explore that with witnesses if that advice is to remain secret.
I'm happy to have this conversation, but it's quite clear that ultimately, in the end, that this committee, we're not going to be the ones. If there are challenges to the High Court, it will be the High Court who ultimately make these decisions.
Public statements about it already.
I haven't made public statements about it. I reiterated points that had already been made, and I'm happy to continue these conversations, but I don't think while we've got the professor as a witness, this is the, if you want to do so after this, we've finished with the professor, I'm happy to do it.
The Attorney General Department may be able to assist us to some degree tomorrow as well, or assist the committee with some of our concerns.
It has not been the practice of the Commonwealth. I think there may have been one occasion which it may have happened, but it's not been the practice of the Commonwealth to make its legal advice public. It's not tabled in the Parliament, and
you didn't do it.
And my expectation would be, and I would hope, that the government would have regard to the comments that have been made on constitutional issues, and if there needs to be some consideration of that, we may see that emerge. But and I would hope that all of the submissions that have raised these issues will be brought to the attention of the relevant advisors. But I don't know that we're going to be trying to juxtapose the government's advice against the opinions that we're receiving.
And ultimately it will be the High Court, not that will...
Well, Chair, I'd accept that, but that's not what you said this morning on radio.
Well, every...
You said that the Solicitor General...
Every grab that you have had... news grab that you've had, do you want me to just grab a sentence or two and then just hold you to that?
No.
No.
Well,
so I think we can have
that's a red herring. You're the chair of a committee. You've made a public statement about the Solicitor General's advice.
You guys didn't.
I'm happy to.
I think we had a witness before.
Yeah,
I think we should go back to the witness.
We need to have a private meeting. We need
Absolutely.
to have a private
I'd be this nonsense.
While we're in public.
I
think we should go back to
so far today, Andrew. Really.
We should go back to to our witness we had before us at the moment.
Well, I was hoping to shorten this, but you've said, Professor Rubenstein, that there are a number of aspects of this bill that are arguably unconstitutional.
Yes.
And perhaps starting with the existing provision,
Yes.
which is Section 35, but originally Section 17 of the 1948 Act.
Correct.
What is your view about the constitutionality of the existing Section 35,
Yes.
or as proposed to be added to in this bill with the addition of the notion of fighting for or being in the service of a declared terrorist organisation?
So, thank you for your question. And as a broad point, I might add, which is relevant to the discussion that's gone on, that as I said in my introduction, because the area of citizenship has been so unclear in its constitutional evolution, it would be very difficult for anyone to say that this is clearly constitutional, because we don't have clarity in relation to the breadth of Parliament's power in relation to the alien's head of power, and we don't have clarity in relation to the meaning of the people of the Commonwealth, which is what I'm going to come to. So Section 35 actually was the former Section 19.
Sorry.
But the reason why you've referred to Section 17 is up until the 4th of March 2002, there was a provision, which many members are aware, which said that if you were an Australian citizen and you took up another citizenship, you automatically lost your Australian citizenship. That was the former Section 17. It never saw a new section because it was repealed under the legislation.
Very keen to do it.
And it was a very important step relevant to our earlier discussion about globalisation and the fact that we are multiple citizens without that undermining our allegiance. But to this question, it represented the removal of that one other provision, which was automatic loss of citizenship. So we had that section, and we have this current Section 35 of automatic loss if you fight for a country at war with Australia. Now, in the public discussion, it went on for many years, as members of this committee well know, many years of discussing whether we would repeal that section. There was an opinion that the former Senator Bolkus, when he was Minister for Immigration, had obtained from the late Ron Caston QC. Now, that advice that he sought was as to the constitutionality of Section 17, which provided for that automatic loss if you took up another citizenship. And his advice at the time was that that section as it stood was unlikely to be constitutional because of the way that it automatically moved someone out of the people of the Commonwealth. Now, in my very old copy here of the Constitution, it looks like this because it goes with me wherever I go, and this is a message to my students that the Constitution impacts upon them every day of their life. This, in Australia, the reference to the people of the Commonwealth has been used significantly by the High Court in relation to the principle of representative democracy and to implied freedoms that are associated with that provision. Part of the argument, and it was tabled in Hansard, and I refer to it in my book on Australian citizenship law, that was tabled in Hansard at the time as further support for the need to repeal that section, not only because of the normative policy value in getting rid of that section, but that there was a real question as to whether it in fact was constitutional. And the concerns about the constitutionality are exactly the same concerns that would apply to the current Section 35, of Parliament being able to remove someone from the people of the Commonwealth in an automatic fashion. So in that sense, in terms of the limitations on the Parliament of what it can do in relation to a person's membership of a constitutional status of people of the Commonwealth, this section raises those same issues. Now, it's never been...
The argument that persuaded me to repeal it.
Well, that's fair enough.
I'll have a talk to you about that. That was not the argument.
We can indeed. But the issue is significant in relation to the fact that Section 35 has never been tested. Now, Section 35 has never been tested because, when I was doing the research for this book, I called the department to inquire as to how many people had lost their citizenship under what was the former Section 19, now Section 35. And the advice was, and is referred to in here, that no one has ever lost their citizenship under that section because that section has never been operational because Australia has never formally been at war with another country. So that, and as a matter of international practice and executive practice, while we have participated in wars, we have never formally been at war with another country, so that provision has never been enlivened. So that's why we have never seen it being constitutionally protected, because there hasn't been a section. And Section 17, the dual citizenship section, was repealed before there was any constitutional challenge to it. So as a core question, it is unclear whether Section 35, as it stands, will be deemed constitutional, and the context that we will get to see this is if this section is passed and someone loses their citizenship under the amended version of Section 35 as it is placed, it's still using that core notion, which is at the essence of that provision, And so one of the challenges will be that it is beyond Parliament's power to remove someone from the people of the Commonwealth in an automatic fashion. So that is part of the argument in relation to Section 35 that also carries on to the principles under these new provisions in terms of Sections 33A and 35A.
Professor Williams, who has made a detailed submission with his colleagues from the University of New South Wales,
Yes.
And who was here earlier today with Ms Pillay
Yes.
and gave evidence to us, said that in his view it was highly likely that the provision would be challenged on a constitutional basis. Would you agree with that? I'm not going to whether or not this challenge would succeed, but just that it was highly likely that there would be a constitutional challenge from someone affected.
Well, if someone is affected by these provisions, so that's assuming that the executive identifies somebody who is subject to these new provisions and that someone is affected by these, and as a person affected by the provisions, I have no doubt that there would be a challenge to the constitutionality of the use of these amended provisions.
Now, Professor Williams also, and I took a careful note of his oral evidence to us, said that he'd given evidence to parliamentary inquiries on 20 or 30 occasions, very often dealing with questions of constitutionality, but that this was the first time, he said, I am prepared to say I'm confident that the legislation under consideration by this committee would be struck down. Do you share that view?
I'm confident of certain provisions being struck down because there are very clear expressions of a person losing their citizenship for a matter that is not proportionate to the objectives of this particular bill. So, for instance, I would be very strongly of the view that the provisions in relation to loss of citizenship on conviction of certain criminal code offences, including that of defacing Commonwealth property, is not at all proportionate to the notion of an expression of allegiance to Australia and would be seen as beyond the scope of the powers. And so, at the very least, that section in
So
my
that's not
mind...
a judicial power point.
So it's not actually even a judicial power.
That is, the legislation goes beyond that relevant
The legislative power.
Even with a conviction. Sorry to interrupt.
That's all right.
Yeah.
No, so you'd call it a head of power point.
It's a head of power point as
just
to the capacity to make a law of that nature that is beyond the power of the Parliament to do that.
Yeah, to give it context, Professor Williams identified three classes of challenge,
Yes.
or three bases, one being the judicial power of the Commonwealth, the
Yes.
Boilermaker's point.
Yes.
The second being
Head of
the
power.
issue of the Roach case point, which you've made as describing it as the
Proportionality.
people of the Commonwealth
Yes,
point.
yes, yeah.
And the third being this question of head of power, as the way
Yes.
Professor Williams described it, but you put that at the same point, but another way. Under the head of power, the alien's power, which has been identified,
Yes.
this is wildly beyond, that
It's not-
particular example, wildly beyond
breadth
the
of that
alien's
power.
power.
Yeah.
Yeah. And disproportionate and therefore highly likely
Beyond
to be
the power
struck
of the
down.
Parliament. Yeah.
Yeah. Oh, that's helpful. The statement that you've made about the purpose of the Act,
Yes.
I just want to make sure I've understood what you've said, Professor Rubenstein. Starting at the bottom of page 2 and going over onto page 3, you've set out the purpose of the Act in the bill, section 4, and then said, I do not believe that the statement, quote, conduct incompatible with the shared values of the Australian community, unquote, is clear, and that it necessarily leads to the next sentence of demonstrating that they have, quote, repudiated their allegiance to Australia, whatever that, end quote, whatever that may actually mean.
Yes.
And as I understand it, the key point's the next point you make. There are many actions of individuals that
Yes.
do not represent shared values
Yes.
in a Western liberal democratic nation, and they are generally criminalised.
Yes.
And that's really your point, that the criminal law
Yes.
is there to deal with antisocial conduct,
Yes.
conduct that is antithetical to the values that we share,
Yes.
conduct that the Parliament on behalf of the community of Australia has determined should be criminal
Yes.
and punished.
Exactly.
if
And
found by a court of competent jurisdiction.
I think that is my most profound concern about this Act, and really does, with respect, respond to the discussion that the Honourable Philip Ruddock and I have had in relation to people who exhibit some rejection of values that we see and hold clear. I mean, an equivalent is paedophilia in society. That is abhorrent to any society. But we would never think of banishing dual citizen paedophiles, or in a system of a rule of law where we have a criminal framework for dealing with antisocial or behaviour that is against the basic values of our society. That is the avenue through which a system of the rule of law deals with it, rather than banishing those individuals or saying you can no longer be a member of our community.
You make another point, Professor Rubenstein, that I don't think anyone else has made, which is that the idea of conduct leading to renunciation by conduct of your citizenship is actually at odds with the way in which renunciation in the Act at present is restricted.
Yes, thank you for giving...
And I wonder if you could expand on that, perhaps by reference to the notion that the Law Council drew attention to in their submission, which is that member states of the United Nations have been required by the United Nations in a Security Council resolution in 2004 in the fight against terrorism to cooperate fully in the fight against terrorism and to deny safe haven and bring to justice through prosecution or extradition any person who supports, facilitates, participates or attempt to participate in the financing, planning, preparation or commission of terrorist acts or provide safe havens. As I understand what the United Nations resolution means and what Australia's position up until now has been, we deal with terrorism by a range of measures under the criminal law.
Yes.
That's why we have legislated so frequently over the last decade and a half to deal with acts of terrorism in their various guises and to criminalise a whole range of conduct associated with terrorism. I wonder in that context whether you can just expand on that, as you put it, conflict between providing for renunciation by conduct in respect of a whole lot of conduct that is already criminalised, and that being at odds with the current restriction on renunciation in the Citizenship Act.
Certainly. So the current Section 33 in relation to renunciation provides an individual with the opportunity to seek to renounce their citizenship. But it's an application. It's not something that one can unilaterally do. In fact, members of Parliament may be aware that there are various Indigenous Australians who have sought to renounce their Australian citizenship by virtue of their belief that they have been the treatment of them as Australian citizens has not been sufficient, and they want to renounce their Australian citizenship. As I've explained, it is all very well for an individual to want to renounce their citizenship, but they don't have the power to do that. It's the government of the day that has to consider whether, in fact, that is in the best interests of both the individual and the nation. Now, part of that is in relation to our international obligations against statelessness. So the provisions that restricted in particular in relation to the current minister are in relation to ensuring that that person doesn't become stateless. But the principle underpinning it is that it's not a unilateral act that an individual can or cannot fulfil. Yet this Act is saying that the individual not only has the capacity, but without knowledge necessarily that their action is going to lead to that, will of their own accord renounce citizenship. So it is an inconsistent meeting of provisions in relation to renunciation. The point that you are making, Mr Dreyfus, in relation to Australia's obligations that the Law Council have referred to, I see as being part of that broader issue in terms of Australia's responsibilities as an international citizen, and our commitment to the international rule of law, which has a very clear message about a fight that all nation states are fighting against terrorism and seeking to bring to justice those terrorists. And that was the point that I was seeking to make earlier in response to some of the questions, that this desire to exclude someone is totally inconsistent with our not only our domestic notion of citizenship, but our international notion of being active good citizens, that we're effectively not fulfilling our obligations within the United Nations system and our commitments to resolutions to dealing with terrorism in the criminal law framework.
Because, if I just understand you correctly, we are not seeking to deal with our own citizens who have committed criminal terrorist acts, but rather simply banishing them.
That's right. We're in fact taking out that connection to Australia so that we no longer have to deal with them, and we're allowing other countries to do the work that is ultimately our responsibility.
Making it definitely another nation's problem.
Yes.
Yeah. You said in relation to the proposed new section 33AA, I'm on page 4 of your submission,
Yes.
this: indeed, there are many oddities in this
Yes.
section, including the use of criminal law definitions without the protections of the criminal law framework in place. Another is the term, quote, acts inconsistently with their allegiance to Australia, unquote, a term which is unclear, even if it is then specified in subsection 2.
Yes.
And I wonder if you could expand on that point
Yes.
about the oddities and about the specific oddity of that term.
Well, I think many of the submissions have raised concerns with the committee about the use of the criminal code in a framework where the criminal law is not the framework for the consequences of using those definitions. So the oddity is that you are bringing in definitions and concepts from an act where those definitions and concepts are set up in a framework where they're the protections of the rule of law to ensure that the proper levels of probity of evidence finding and so forth are relevant to the consequences of those definitions. They do not appear here within this Act. And so the oddity is that you are seeking to use principles and provisions from an Act where there are protections and placing it in the context of another Act. And I would say, as I've said several times now, for something as profound as membership of the nation state, so that within a criminal law context, your liberty, of course, is taken, and that's significant if you're placed into jail. But this is that on multiple levels in terms of the fact that you are forever removed from that community by virtue of the loss of status of citizenship. So I think that is concerning as well as unusual, or an oddity in relation to the mixing of those principles. In relation to the second part, in terms of this consistent reference to acting inconsistently with one's allegiance to Australia, our discussion today by very well respected members of this committee shows that there are different views about what that means, what allegiance to Australia means. And as a community, if we are going to reject someone on the basis that we think that they no longer hold that connection to Australia, there must be a much more substantial democratic engagement with what that represents, rather than a piece of legislation such as this, which seeks to automatically...
I do hope we will have that.
Well, and how one holds that sort of discussion, I think, is extremely... I would implore upon Parliament to do that in a way that is totally productive rather than counterproductive, because I think the real concern about placing these discussions in the context of citizenship and in the context of dual citizenship is that in a country like Australia that is made up of so many people with connections to other nation states, it comes back to my point about making more vulnerable people who would otherwise feel secure in their membership of Australia, and that would have a counterproductive consequence in relation to these other avenues that we're seeking to fulfil in terms of educating against terrorism, of making people feel committed to the Western liberal democratic system.
What is the vulnerability that you're talking about, Professor Rubenstein?
Well, the direct vulnerability of loss of citizenship means the loss of your capacity to live in the state, the nation state that you have been intimately connected with,
that's what it does
and the
mean.
vulnerability to the families associated. So it's not just the individual.
Very significant consequences.
Absolutely so.
And may influence whether they're prepared to be involved in terrorist activity.
But it also may influence, with respect, their sense of connection to the Australian community if they feel that they are being treated equally and they are seen as other, and that they would not otherwise have even thought about terrorist activity, except that the public discourse is now seeing them as other and of seeing them as suspect and of seeing them as not equal members. I think
we're
that that's the other issue.
slightly at issue, but I would like to hear whether you have in mind,
Yes.
because it may be helpful, amendments to the criminal code that you think are more likely to have an impact on those who are engaging in terrorist activity.
Well, I would certainly be happy to call my expert colleagues in the criminal law to do that for you, and they can be consulted easily in relation to the criminal code. My expertise is in citizenship, and I'm more than happy to speak about those areas that I'm an
You've been
expert.
putting the argument to us on the basis that the amendments to the criminal code could achieve it, but you can't tell me of any way in which it might.
Because, with respect, I'm doing it in the context of our belief in a system of a rule of law where we have a criminal code system. We could get rid of the criminal code altogether
I'm not
if
suggesting
we
that
didn't
at all.
believe in those fundamental principles that are at the base of our system of a rule of law.
But the
Why
point-
shouldn't they apply to dual citizens in the way that to any other citizen they apply?
Well, the point I made before, we've already dealt with those who engage on behalf of foreign power against our forces, and I regard those who engage in a terrorist organisation that doesn't even respect the rule of law as doing something that is far more heinous. And I think there is a real prospect that measures of this sort could influence people's willingness to engage in this sort of behaviour. And I can't see, with the radicalisation that's going on in our jails and the sort of behaviour that we are aware that continues for those people who have been convicted, that the criminal law system is having any impact.
Well, I would encourage the committee to be gathering evidence exactly on that point to see how experts in the areas of radicalisation and anti-radicalisation
Well,
can
they certainly
operate
haven't been
in...
bringing submissions to us suggesting alternative ways in which we might deal with it.
But that doesn't mean that they can't be sought out.
This bill on its face, Professor Rubenstein, is seeking to deal with, at the broadest, people who have committed a range of already criminalised conduct, criminal offences, and been convicted for those offences, and others who've engaged in wrongdoing, if I can put it at the broadest. How does the bill create, if it becomes law, vulnerability for, if I could call them innocent dual citizens, people who've neither been convicted nor engaged in the range of conduct that the bill is directed at?
Because I think it creates an acceptance within our democratic system that you can start to identify matters that are seen as inconsistent with the values of a society. So it's the beginning of a slippery slope of other matters, such as, as I've said, paedophilia or other aspects that we do not want to encourage in our society. Once you allow the executive to determine there are aspects of behaviour that then lead to your exclusion from society, what is to stop those next steps in relation to other activities? So there are the people who are vulnerable because they're actually not aware that their activity. So my case of Senator Fioranti-Wells, for instance, people who are dual citizens who might be supporting co-asset and not realising. So there are those who are doing things innocently that would come within the scope of the criminal law as it stands. But I think your point is how would it be of concern to others? And it's my point that as a matter of principle, it starts a road towards the executive's power to exclude individuals. And history beyond Australia shows that that is of real concern. And as in the one of the high court cases that has been referred to, Riame ex parte the Commonwealth, the court did recognise the concern against deprivation of nationality because of the capacity for dictatorial systems to then utilise those principles in, creating a very anti-democratic framework.
So that even if, say, the list of offences under 35A, which is the clearest part of this bill, that is conviction-based,
Yes.
were limited to a narrower range of convictions
Yes.
or narrower range of offences, would you still retain the view that the bill reinforces the vulnerability of which you've spoken?
Yes, because it still comes within the concern about the automatic loss on that conviction, as opposed to a further question as to whether that conviction in and of itself represents a proper understanding of repudiation of allegiance, or something that is directly at conflict with the continuation of the nation state.
You've, in your submission, described these amendments as very harsh measures.
Yes.
Is that something you could expand on?
It really relates to my earlier point that any right that is relevant in a democratic society is linked ultimately to your membership, your status in that society. So we can think of the core aspects of citizenship: voting rights, rights of residence, the capacity to serve in the public service. Those aspects become contingent. And so the harshness is in terms of the notion of the right to have rights. That is, essentially cut out of the framework, and so the consequences of loss of citizenship are extreme in terms of the capacity to exercise any of the rights associated with the Australian Constitution.
Thank you very much, Professor Rubenstein.
Can I just respond to this letter that
yes, I handed it to you and then forgot about it.
So I thought I'd just give you a brief response.
Yeah, I'll just preface that with a question by saying I asked Mr. Neve, and I've asked some other witnesses about it, and I'm going to ask the department about it when they turn up tomorrow. But the department's taken an opportunity of, in a 2-page letter, giving some indication of the arrangements that will support the implementation of the bill, which involves, to paraphrase it, a lot of communication between a lot of government departments, sharing of information, leading up to the Secretary of the Department of Immigration, who will then bring the matter to the attention of the Minister.
So I've read that paragraph, and it doesn't make clear to me how that would be done. It's just a broad statement that there would be close cooperation across government. And the point that I'd like to make, and in fact, the Honourable Philip Ruddock might also, in the context of the provisions to do with repeal of dual citizenship, one of the issues at the time in relation to the idea that if you took up another citizenship, you lost Australian citizenship, was that it was actually difficult to know who wasn't a dual citizen, in that there was no automatic system by countries to let Australia know that someone who was an Australian had taken up their citizenship. So that in reality there were a lot of people who were dual citizens who may not even been aware themselves that they were citizens, and certainly the Australian government wasn't aware. And so there was a concern. That was one of the other aspects of the concern.
The real matter of concern was there were a lot of Australians who were dual nationals and who could not forsake it because of the country who accorded them nationality or citizenship, refused to recognise renunciation. And places like Greece, I think, were...
There were multiple reasons for it, but one of them was an operational reason, that it was difficult between governments to actually identify who had citizenship of other countries.
I'm not sure that's the reason that I was able to persuade my colleagues.
That certainly was one of the issues of discussion. And I think that highlights really the concern that is alluded to here and is not clear here, and I think it would be very interesting to ask further how that would actually operate in an international sense in terms of determining exactly who is a dual citizen of the other countries. It's not impossible, but it's not clear as to how that would happen. So operationally, I think there are really significant practical questions that flow from that paragraph. And it would be interesting to ask them to reflect on the operation of that former Section 17 regarding dual citizenship, when that was an issue that was certainly raised in various parliamentary reviews of the former dual citizenship provisions. So I just thought I would add that.
Is that uncertainty that you've just been talking about one of the reasons why nobody seems to know how many dual citizens there are?
Yes,
in
absolutely.
Australia?
It's unclear because of that lack of knowledge on many people's parts in terms of the eligibility and recognition of dual citizenship, of citizenship of another country, but then also the actual recording of those individual citizenships in their other country of citizenship and so forth.
Are you able to hazard a guess? FECA were here before and said that the last statistic that had been offered was 4 to 5 million
Yes.
in 2000.
I don't have any capacity to do that. But
Yeah.
in relation to the nature of a multicultural society like Australia, it is profoundly likely that most people have some connection to someone who is a dual citizen.
Thanks, Professor Rubenstein.
Professor Rubenstein,
Yes.
could I just briefly, just so I understand your perspective on some of the cases that have already been
Oh, yes.
decided
Yes.
in Australian law, if I could just run very quickly just
Certainly.
4 examples, and if
Yes.
you could respond to me whether you think these cases meet the test relating to allegiance and
Sure.
relating to conduct encapsulated in this bill. So Mr Mohammed Elamar, as you know, born in Tripoli, Lebanon, found guilty of participation in a conspiracy to do acts in preparation for a terrorist act, sentenced to 28 years, non-parole, 21 years. Mr Abdul Hassan, born in Bangladesh, convicted of participation in a conspiracy to do acts in preparation for a terrorist act, 26 years, non-parole, 19 years, 6 months. Mr Fahim Lodi, born in Pakistan, convicted of a series of offences, including doing a certain act in preparation, collecting documents connected with preparation for a terrorist act, possessing a certain thing connected with preparation for a terrorist act. Mr Bambrika, born in Algeria, convicted and sentenced to 15 years, non-parole period of 12 years for terrorist-related offences. Do any of those cases reach a standard perhaps where their allegiance to Australia, where their egregious breach of their first loyalty to Australia and its people deserves more than just the criminal law dealing with them?
So I understood your question as to whether they would come within this Act. And so the first question would be, well, birth in and you've referred to them being born in other countries. As we know, just by being born in Australia does not mean that you become a citizen of that country. So we're not sure that each of those people who are born in other countries are necessarily dual citizens in terms of bringing them within the purview of the Act. Then each of those offences that you referred to, we would need to look to see under these provisions whether they would come under those provisions. But your more profound question, which is in essence, should activity like that be seen to be sufficient to bring one within the context of a government's power to say you no longer are a member of our community? And my overall normative policy approach to that is that it is the criminal law that we should be using to punish people, that we do not use citizenship as a form of punishment for abhorrent behaviour. There's no question that we should identify it as abhorrent, that we should criminalise it, but the essence of my submission is that we can't use citizenship as the frame for punishment or as a frame for saying you are no longer committed to this country. The notion of renunciation is there to say that if an individual explicitly makes the claim to the government that they no longer want to be recognised as an Australian citizen, that is very different for us to determine that their action is actually representing that. And internationally that's been recognised also within the US system and other Western liberal democratic systems. It's not for the executive. It comes back to my basic point. It takes the balance away from an equality between citizens, between the individual and the state, and gives that power back to the state in a way that is of concern in a Western liberal democratic society.
So in your view, the countries that have done that, that have gone down this path, the United Kingdom and
Which are
Canada
they?
and
Just
France.
before you- the premise
Well,
of
I
this
didn't.
question is that there are some countries
I
that
didn't
have gone down
interrupt
this
you,
path.
Mr. Dreyfus.
I'm interrupting
I've been
because the
listening
premise of this
patiently.
question is false.
I've
All
been
right,
listening.
Well, let him ask the question
patiently,
first, and then I'm sure the professor
to your
is
extended
able to.
Shakespearean soliloquy these past hours, but if I could just say those countries that have gone down this path, Professor.
Yes.
This is truly pathetic.
No.
The premise to the question should be no country has gone down this path. So if you ask a question that says other countries have gone down this path,
you ask your
it's a false
questions,
premise.
Mr. Dreyfus, and I'll ask mine.
Yep.
But Professor, those countries that have seen it necessary for dual nationals to take away their citizenship, France, the highest court in France, has found it legal for France to have done that for a Tunisian man recently, as I understand. I understand the United Kingdom has done it on some 27 occasions. Canada and others. Your view is that taking away the citizenship of those countries in response to the sort of conduct that we're trying to encapsulate in this bill, those countries have erred as well.
So there are 2 points to make. One is that the legislation, as is being intimated, but the legislation in other countries is very different to what this legislation is doing, and so that.
But the principle of acting against
Yes.
citizenship,
Yes.
you know,
I understand what
you're
you're
saying you can
Yes.
see no circumstances. So I guess my question
Yes,
to you...
and I appreciate the question because I think it is important. I think that there has been a lot of criticism of those countries for taking that step in relation to the very principles that I'm arguing for. So that even though that there are steps that have been taken to amend legislation to provide in different contexts the revocation of citizenship, I accept that that's been done. There's a lot of critique of that in relation to the consequences of what that will have, of the consequences of that for the democratic framework of those countries, and also for the issues that we've been talking about in terms of the counterproductive consequences of that. So,
You better send me some of the critique. 'cause
Yes, I'd
we
like to
just
see
got
some of
back
the
and
critique as
I
well.
didn't hear much of it while I was there.
well, I'm very happy to. There is an entire website that I can send to the committee, and I'm happy to do that, called Udo Citizenship, where it's a whole feature on a critique of the banishment and the use of exile in that sort of
And
context.
I just simply say, we've been there and we didn't get it while we were there. It wasn't top of the mind.
Yep, okay. No more questions. Thank you for giving evidence at the hearing today. You'll be sent a copy of the transcript of your evidence to which you may suggest corrections. If you have been asked to provide any additional material, please forward this to the Secretariat as soon as possible. If the committee has any further questions, the Secretariat will write to you.
Thank you very much. Thank you.